Hello and good morning. I'm Stephen Tromans. I hope you can see and hear me okay. Welcome to this webinar, another in the series 39 from 39. We're covering today the topic of air quality. We have looked at air quality in previous webinars, particularly in the context of the Environment Bill, but it seemed appropriate to have a particular focus on air quality today, largely in view of the recent decision just over a month ago of the Court of Justice in case 664/18 against the UK, where the UK was found by the court to be in serious, systematic and persistent breach in relation to air quality limits under the directive, and had done nothing essentially for over a decade in relation to this. So we've had a bit of a respite, I think, from air quality problems during lockdowns and so on. But if one looks at satellite images, you can see that throughout Europe, air quality is going down as, quote, normal life is resuming. So I think it's a fairly short-lived respite that we've enjoyed. What we're going to cover is essentially three things. Steph David is going to look at the Court of Justice decision in some detail and the implications of that. And then Catherine Dobson is going to look at essentially the post-Brexit landscape for air quality. What happens now we no longer have the Court of Justice scrutinising what the government is doing and local government is doing in relation to air quality. And then finally, Nigel Pleming QC is going to take a slightly broader view on some other legal mechanisms to secure improvements in air quality. It's a bit more of a think piece, really. That one hopefully will stimulate some thoughts and some debate. Just a couple of practical things. I'm sure you're familiar with Zoom and with webinars, but please do make use of the Q&A function. If you can find the button on your screen. If you want to ask us questions, we will either try to answer them online or we will have a time for questions to be addressed at the end. So please do feed those through. We'll do our best to give you answers to them. And the materials, including the slides and other materials, will be available later. You'll get them via our marketing department by tomorrow at the latest. So without more ado, I think what I'll do is hand over to Stephanie, who's going to deal with the Court of Justice decision. Stephanie, over to you.
Thank you, Stephen. So as Stephen said, I'm going to cover the very recent judgment of the Court of Justice of the European Union. As you'll see, my opening slide there, it's quite difficult to find images when you're talking about air quality, but that's the specific NASA satellite, the Aura satellite, which is geared towards observing Earth and obtaining measurements of ozone, aerosols and key gases, including nitrogen dioxide. So I thought it was a rather nice photograph and an image to break up the slides. But Catherine, could you go to the next slide, please? So in terms of, just while we're sorting out the slides, in terms of the actual declaration that was sought by the European Commission, you'll see there the wording of that declaration. So as Stephen mentioned, there are essentially two elements to it. The first one was that the UK was systematically and persistently exceeding the annual limit value for nitrogen dioxide in respect of 16 zones and the hourly limit for nitrogen dioxide in the Greater London, urban London area. The second element of the declaration sought was in respect of the failure of the UK to put in place appropriate measures to ensure compliance with the limit values for the nitrogen dioxide in those areas. I just thought it'd be helpful to see the wording of the declarations in the first instance before I break that down a little bit further. Next slide, please, Catherine. So then in terms of the key definitions within the Air Quality Directive, I'm sure many of you are familiar with these definitions, but the limit values are essentially the levels fixed on the basis of scientific knowledge in respect of different pollutants. and those limit values need to be attained within a given period of time and not to be exceeded once attained. So how that works practically is, in respect of nitrogen dioxide, for example, member states were required to meet the limit value by the 1st of January 2010. There are limit values for different averaging periods. So first of all, over 1 calendar year, and second in respect of a 1 hour period. And then we've got air quality plans, which are essentially plans that set out measures in order to attain the limit values or target values. Zones are essentially kind of administrative areas that are used to assess air quality within the territory of a member state. And then you'll see there the definition for ambient air. Next slide, please, Catherine. So Article 13, which is the key article in respect of the first declaration sought by the Commission, essentially requires member states to ensure that levels of a number of pollutants do not exceed the limit values laid out in Annex 11 to the directive. And what's important about this article is that it's an obligation of result. And therefore, simply by exceeding the limit values, that's sufficient to find there has been infringement of that particular article. There is provision, however, in Article 22 for a member state to actually postpone the specific deadline within the annex in relation to achieving the limit values. But there are certain conditions with regards to that extension of time. Namely, they can apply to extend the period for a maximum of 5 years and on the condition that the air quality plan is established. Next slide. So Article 23 informs the second declaration sought by the Commission. It's geared towards pollutants that are in ambient air that exceed the limit or target values. And there's therefore a duty on member states to ensure that air quality plans are established. If the attainment deadlines, so the deadlines by which the limit value has to have been reached, have already expired, the key provision within this article is the air quality plans shall set out appropriate measures so that the exceedance period can be kept as short as possible. And on that point, I'm sure many listeners will recall the decisions in the Klein Earth litigation, particularly the 2016 judgment of Mr. Justice Garner, where he said that the Secretary of State had given disproportionate weight to considerations of cost, political sensitivity, and administrative difficulties. The focus had to be on keeping the exceedance period as short as possible. Next slide. It's also worth flagging that Article 3 does incorporate an annex to the directive, and that annex specifically lists certain information that needs to be incorporated in the air quality plan. The air quality plan must be communicated to the Commission so that essentially the Commission can comment upon whether satisfied the air quality plan is sufficient to meet the obligations under the air quality directive. And pursuant to Article 27, the member states have a reporting obligation, which means they have to provide the Commission with updating data to ensure that they are on track to meet the limit value. Next slide. I'm not going to go through the chronology in any detail, but it's in the slides for you to refer to. The first set of plans were submitted by the UK government in 2011. They related to 40 zones. Importantly, for the recent judgment, the UK government only applied for extensions for 24 of those zones, i.e. it extended the period by which the compliance with the limit value from 1st January 2010 to the 1st January 2015. Not 16 zones, which is the 16 zones that were addressed in this case. As you'll be aware, there was a challenge in the UK Supreme Court, and that decision was in May 2013. There was then a reference to the Court of Justice before it came back to the Supreme Court in April 2015. And essentially that decision found that the 2011 plans, particularly for the 16 zones, meant the UK was in breach of the obligations under the air quality directive, and therefore a mandatory order was issued. Then there were 2015 plans. Again, these related to 38 zones, and you'll see there the various compliance dates in respect of some of those zones. Next slide. It then went back to the High Court and it was considered by Mr. Justice Garnham. The High Court found that even the 2015 plans were in breach of Article 23 for the reasons I referred to before, namely that a disproportionate weight was given to costs and political sensitivities. The Commission then issued a reasoned opinion pursuant to Article 258 of the Treaty on the Functioning of the European Union, which essentially the procedure that is followed when a member state fails to comply with its obligations under EU law. Following that, there were further plans, the 2017 plans, and they were sent to the Commission in July 2017. In January 2018, what then happened is the Commission organised a summit on air quality. That summit was essentially geared towards member states that were facing infringement proceedings. The UK submitted their measures following that summit, and the Commission determined that the measures were not sufficiently timely, effective, credible measures to address the ongoing exceedances, and therefore the UK was still in breach of the obligations of the Air Quality Directive. Next slide. So in terms of the declarations that were sought, the first declaration related to the systematic and persistent breach of Article 13 of the Air Quality Directive. Pursuant to Article 258, which is the article in the Treaty on the Functioning of the European Union, you need an objective finding that a member state has failed to fulfill its obligations. As I mentioned before, Article 13 is an obligation of result. So by virtue of the fact that the limit values had been exceeded, a breach of that article had been established. And on the basis of the evidence before the Court of Justice, considering the annual air quality reports, particularly between 2010 and 2017, it was clearly the case that the annual limit value had been exceeded. Next slide. One interesting point that crops up in that part of the decision is in respect of two issues. So first of all is in relation to the fact that the anticipated reductions in relation to nitrogen dioxide emissions by virtue of the vehicle emission standards had not been achieved. And the UK essentially said that that was largely the reason why they'd failed to comply with their obligations. They said the fact that the anticipated reductions hadn't been achieved was also exacerbated by cheating scandal by car manufacturers in Germany. The second point made by the UK was another reason why they said they couldn't comply with the obligations, namely that diesel transport is a European-wide challenge. The Court of Justice gave those points very short shrift. Essentially, they said that the motor vehicles falling within the standards set by the EU, not the only cause of emissions. And in any event, EU rules relating to standards of vehicles do not exempt member states from their obligations under the Air Quality Directive. Next slide. So the UK ran a very interesting argument in respect of the breach of Article 23 point, which is obviously to do with the air quality plans, namely that the Commission had applied an impermissible presumption, namely that its case in Article 23 follows simply from the fact that the exceedances of limit values in respect of the 16 zones had been established, i.e. the fact there's a breach of Article 13, it follows from that there's a breach also of Article 23. The court rejected that argument. It accepted there is a direct link between Article 13, so exceedances of limit values, and Article 23, air quality plans, but then noted the following just there, which is that exceedances of a certain magnitude and duration, the evidence that the UK has not taken the measure it is required to take. Those measures are the adequate measures to ensure that the exceedance period is as short as possible within Article 23. Next slide. So in terms of the Court of Justice findings on Article 23, the member states, of course, have a discretion with regards to the measures they adopt, and ultimately it falls on a case-by-case analysis. They have an evaluative analysis in respect of the particular air quality plans. In terms of the 2015 plans, the Court of Justice looked at the detail and established that they hadn't addressed all the information within the Annex 15. In terms of the Article 2017 plan, the key concern there was that the exceedance periods were longer than in 2015, and therefore the UK had failed to comply with the obligation in Article 23. And now I'm going to hand over to Catherine.
Thanks, Stephanie. So I'm now going to look at the air quality protections in the UK post-Brexit, focusing on two questions. So first, is the future likely to see major divergence between EU and UK air quality targets? And secondly, in the absence of the Commission and the CJEU, how will the UK government be held to account for success or failure in meeting air quality targets? And I should just note at this stage that this short presentation is going to focus on ambient air quality rather than other pollutants. And it's also going to focus on the position in England, bearing in mind that many aspects of environmental regulation are devolved matters. So, the position before Brexit was, of course, that the EU Air Quality Directive sets legally binding targets for a range of pollutants, including nitrogen dioxide and fine particulate matter. And the Air Quality Directive was implemented into domestic law through the Air Quality Standards Regulations 2010. Under the Withdrawal Act, all EU-derived domestic legislations continues to have effect in domestic law. So the air quality regulations have become retained EU law. They've been amended to ensure that they remain operable outside the EU framework, but those are only minor amendments, doing things like updating references to EU institutions and EU legislation, but no major changes. The key point is that the substantive air quality targets that were in the Air Quality Directive remain the same in the air quality regulations. This includes the obligation, which was the focus of the Commission infraction proceedings, to have and implement an air quality plan that will ensure compliance with limit values within the shortest time possible. So the question going forward is whether limits in the air quality regulations can be changed. Under Section 7 of the Withdrawal Act, subordinate legislation such as the air quality regulations has the status of domestic subordinate legislation and subordinate legislation. And in the absence of the EU doctrine of direct effect, the air quality regulations can, of course, be amended or repealed by primary legislation or by delegated legislative powers. And the Withdrawal Act itself confers a number of delegated legislative powers, enabling amendment of the air quality regulations. It should be noted that during the passage of the withdrawal bill through Parliament, it was proposed that amendments should be introduced to provide that secondary legislation, such as the air quality regulations, could only be amended by primary legislation to provide a degree of entrenchment, but that was rejected. Instead, the Withdrawal Act contains limited protections against modification or revocation of secondary legislation, which was originally made under the European Communities Act, such as the air quality regulations. And under Schedule 8, modifications can only be made through secondary legislation that's subject to the affirmative resolution procedure. It nonetheless remains the case that the UK government could amend existing air quality limits or review the deadlines for them. The ability to change the retained EU air quality targets and deadlines will be limited by the level playing field provisions of the EU-UK Trade and Cooperation Agreement, the TCA. The TCA requires non-regression in the level of environmental protection by the UK from the end of the transition period. So this means that the UK must not reduce or weaken the harmonised standards on environmental protection that were in place as at 31st of December 2020. The TCA also provides that EU environmental laws which contain targets, such as the air quality targets, continue to be binding on the UK, even where their attainment, the attainment of the target is envisaged after the end of the transition period. So I think taken together with statements from the government making clear that they do not have any intention to change the limit values that are retained in the air quality regulations, alongside the requirements, the non-regression requirements of the TCA, it's unlikely that the existing air quality targets will be lowered in the near future. The real issue is going forward, whether we can expect future divergence in targets between those set in the EU and those adopted in the UK. Now, the TCA doesn't require harmonisation with EU standards, meaning that in principle, the UK can adopt its own different rules on environmental issues. However, the freedom for the UK to deviate significantly from EU regulation is to some extent curtailed by the terms of the TCA. Under the TCA, the UK is committed to continue to apply certain general principles of EU environmental law. Importantly, that includes the precautionary principle. Both the EU and the UK have made a general commitment to strive to increase their respective environmental levels of protection. And either party under the TCA can take appropriate rebalancing measures if there are significant divergences in environmental or climate protection, but only where those divergences materially impact on investment and trade between the parties. So in theory, the level playing field framework represents an important constraint on the UK's freedom to enact significantly different environmental rules from those enacted at EU level. However, it remains to be seen in this area, as in many others, how the level playing fields of the TCA will be applied and enforced. In terms of future targets and deadlines, the environmental bill, which is currently going through Parliament, is likely to be the mechanism through which the changes are made. And there are a few things to note about the target setting powers and obligations in the current version of the bill relevant to the direction of travel. So, first of all, the environmental targets will be set by the Secretary of State, and they will be contained in secondary legislation. The Secretary of State is required to seek advice from persons that he or she considers to be independent and to have relevant expertise, but it is ultimately a matter for the Secretary of State. The Secretary of State only has a duty to set one long-term target in relation to air quality, although he has powers to set additional targets, and that's in addition to a specific target to set a target for PM 2.5. And then under clause 4 of the bill, the Secretary of State has a duty to ensure the targets set are met. So in theory enforceable, but the current version of the bill includes an express power for the Secretary of State to revoke or amend existing targets. That power is subject to conditions, but those conditions include taking the view that changes in circumstances since the existing target was set or amended mean that the environmental, social, economic or other costs of meeting the target would be disproportionate to the benefits. So quite a broad discretion there to amend targets. So overall, I think the legal framework created by the Environment Bill will provide weaker legal protections for air quality targets and deadlines. And this was always going to be the case post-Brexit, that environmental targets no longer entrenched at EU level were going to be amenable to change by Parliament. But because the targets are contained in secondary legislation rather than primary legislation, because they're set by the Secretary of State, and because there's an express power on the Secretary of State to change and lower those targets, I think it will be legally relatively easy for the Secretary of State to change targets and deadlines. And I emphasize legally easy because I think in the future it's going to be political pressure rather than entrenched legal obligations that will be key in ensuring that targets are not changed when the going gets tough for government. So moving to the second question, how will the UK government be held to account for success or failure in meeting air quality targets in the absence of the Commission and the CJEU? The governance gap left by departure from the EU and loss of these institutions was identified early on, and the government's initial response was that judicial review procedures were adequate to ensure legal accountability of government and other public bodies in this domain. However, when Michael Gove took over as Secretary of State, he decided that that wasn't enough and that a new independent body would be needed, and the Environment Bill therefore creates the Office for Environmental Protection, which is given responsibility for taking action in relation to breaches of environmental law by public authorities. Now, a lot has been written about the role of the OEP and its enforcement powers. Concerns have been raised by its lack of independence, but I just want to focus on the question of how its enforcement powers in relation to meeting existing ambient air quality targets compares with the position pre-Brexit, which Stephanie has summarised in relation to the recent infraction proceedings. Now, this issue was considered by the Environment, Food and Rural Affairs Committee in one of its pre-legislative scrutiny meetings of the Environment Bill back in January 2019. The committee was hearing from a number of lawyers, including Professor Maria Lee and Daniel Greenberg. And the chair of the committee posed the question, could the Client Earth litigation happen after Brexit? As Stephanie has reminded us, Client Earth brought successful judicial review proceedings challenging the UK government's failure to meet air quality limits and have an adequate air quality plan in place. And the short answer to the question is yes, it remains open to entities such as Client Earth to bring judicial review challenges of the government on the basis of a failure to comply with air quality targets, as they remain part of retained EU law under the air quality regulations. And this will be the case both before and after the Environment Bill becomes law. Now, once the Environment Bill becomes law, the OEP could also bring an environmental review, or in an urgent case, a judicial review, on the basis of a failure of the Secretary of State to comply with duties in relation to the limit values that are in the air quality regulations, and presumably also those such targets as are introduced under the provisions of the Environment Bill itself. The more important question, I think, is whether judicial review proceedings taken for failure to comply with air quality regulations or new targets made under the Environmental Bill when enacted, is whether those powers will close the governance gap left by the loss of the Commission as the CJEU. And I think the answer is no, for two reasons, at least two reasons. The first is that compliance with obligations will be considered on the basis of judicial review principles. Now, this will be easy enough to apply when you're looking at whether or not the specified limit values have been met, and the Administrative Court will be comfortable with that. But when it comes to more evaluative concepts, such as the requirement to implement air quality plans to ensure compliance within the shortest time possible, it's not clear to me that the Administrative Court will be as probing as the CJEU was, and is willing to question the judgments that the Secretary of State has made in terms of what is the shortest time possible. And I would invite you to compare the reasoning of the CJEU in the recent infraction proceedings, where it was went into a lot of detail in unpicking and criticising aspects of the UK's air quality plan, with the, for example, position taken by the Divisional Court in the challenge to the third runway. It's not clear to me that the same degree of scrutiny of government action will be available in our domestic courts. And secondly, at a very basic level, the OEP and ultimately the court do not have the power to levy fines in respect of government failure to meet its air quality targets or limits. So I think even though accepting inevitably no domestic body could have the independence of an external body such as the Commission or the CJEU, the OEP that's been created to plug this governance gap really lacks the teeth to do much more than a private litigator can do. It can't award damages or impose fines, it can't issue orders. It will also have to go to court if it wants to have an order obtained, a mandatory order. So it's really no different from the position of a private litigator taking the government to court. And that fact, taken together with the fact that in the future all our air quality targets are going to be in secondary legislation and amenable to change, means the future of environmental accountability is going to be more reliant, I think, on strong political oversight rather than strong legal oversight. But that's all subject to what Nigel says about more creative ways of using the law to enforce air quality limits. So I will hand over to Nigel on that note.
Thank you, Catherine, and good morning, everybody. The air is no respecter of national boundaries, and some of you will have seen over the last few days coverage of microplastic pollution that is, quote, spiraling around the globe, irritating lung tissue and leading to serious disease. What I'm going to look at, however, is the national position where there may be room for national action other than the type of challenge by Client Earth, which is to non-compliance with regulations. This is local claims in relation to air quality damage caused by heavy traffic, industrial activities, etc., looking briefly at public law and then at possible private law approaches. As you can see from the slide, the topics I want to cover are general public law grounds, human rights-based claims, public and private nuisance, and possible precedents or ideas from climate change litigation. Next slide, please. Now, public law grounds, there's already been reference by Catherine to the third runway case, Spurrier and the Transport Secretary. This was an opportunity to test the position in relation to rationality challenges, reasonableness challenges. And in a regulated area, heavily regulated area such as air quality, there may be little scope for such a challenge. As you'll see from the quote from paragraph 268 in the divisional court judgment, they said this: a policy which may not be deliverable is not by virtue of that alone irrational, which was somewhat discouraging. However, at the end of the section, paragraph 277, you can see this possible hope when it comes to the development consent order stage, that the applicant has to satisfy the Secretary of State that the Northwest Runway Scheme will not breach any air quality requirements as properly construed, importantly, not as construed by the Secretary of State. So there may be scope in the right factual air quality case for deployment of an irrationality challenge, but it's likely to be an uphill challenge. Next slide, please. Now, an argument recently in play is a combination of claims based on the European Convention on Human Rights. On this slide, you will see reference to the investigative or procedural obligation under Article 2. And the minimum requirements of Article 2 to carry out an investigation set out in various cases. Not on the slide, you might have noticed the recent case Hanan, H-A-N-A-N, against Germany, a judgment in February this year, and summarized, as the principles are summarized in the Sharon Grice coroner case in 2020. But here I've set out the basic approach which you can find in the AB case. And this is the importance of this case, is that a fresh inquest, a fresh investigation was ordered because of new evidence from Professor Holgate in particular, that it was likely that unlawful levels of air pollution contributed to the cause and severity of the 9-year-old Ella's fatal asthma attack. As a result of that decision, a new investigation was duly held, and many of you will have picked this up from the media, that the assistant coroner at the second inquest in December 2020 decided that exposure to excessive air pollution was a material contribution, possibly leading to the 9-year-old's death. More information may be set out in the coroner's prevention of future death report, which we haven't yet seen, but already his verdict has had wider consequences, with moves in Parliament to add a health inequalities target to the Environment Bill. Not on screen, but could I point you to a recent article by Alex Samuels, which looks at the consequences of Ella's case and whether or not the failings may translate into legal liability. the title of the paper is there a legal right to clean air? It's in the JPL. I'll make sure you get all of these references after this talk is over. At the end of his paper, he says this: the judge may adopt a conservative or cautious approach, or a liberal or an adventurous approach. I want to come back to that, and also to the right to life. If I turn, next slide, please. I want to touch briefly on nuisance. Public nuisance, which you'll see defined from the Goldstein case in 2005 at the top of the slide. The Police Crime and Sentencing Bill by Section 59 is intending to abolish the common law offence of public nuisance and replace it with a new offence of doing an act or omitting to act, as you can see in the second bullet point, where a person's act or omission causes serious harm to the public or a section of the public. Stephen Tromans convincingly argues in our most recent Chambers Planning, Environment and Property newsletter that public law nuisance is wide enough to extend to this kind of claim. As he says, it's not fanciful to argue that local councils or government agencies which clearly fail to comply with duties to avoid air quality limits being exceeded, thereby undoubtedly cause damage to public health and could be committing a public nuisance. In addition to public nuisance, there's private nuisance, and there's a small extract there from Williams and Network Rail Infrastructure, which is worth looking at through paragraph 45 in particular, which ends, provided by reference to all the circumstances of the case and the character of the locality, and according to the objective standards of the average person, the interference with amenity is sufficiently serious, then there will be an actionable private nuisance. Of course, in this kind of case, all the major evidential problems will arise as to who is the actual or particular culprit. Next slide, please. This is a list of cases in climate change litigation. You will know, many of you will know the agenda case, but there are other examples: Pakistan, Switzerland, Ireland, Peru, and elsewhere, the US and around the world, where claims are based on human rights breaches, particularly under, not just the procedural breaches, but under the right to life under Article 1 and the right to a private life under Article 8. Of the cases, the Leghari is particularly interesting. And perhaps you could spend some time somewhere to have a look at the paragraph, I think it's 20 or 21, where the judge there deals with the concept of environmental justice. And finally, next slide, please. Could I mention briefly the concept of climate conscious lawyering? I mentioned the Alex Samuels article, and here's the reference. And this sentence: the judge may adopt a conservative or cautious approach, or a liberal or an adventurous approach. That idea has been developed elsewhere. And in 2020, Mr. Justice Brian Preston, who is the Chief Judge of the New South Wales Land and Environment Court, came to London and spoke at length about implementing a climate conscious approach in daily legal practice. That was then recently published as climate conscious lawyering in the Australian Law Journal. Next slide, sorry, this slide, and you'll see the quote. What I've done is take the first paragraph and substitute climate change to poor air quality. And you'll see it reads quite well, that if you read through that paragraph, I'll let you read it. But at the end, the message from Justice Preston is clear. All lawyers, including judges, need to be fully aware of the enormous, indeed existential problems caused by climate change, and I would add, by environmental problems such as air pollution. And he makes a convincing and detailed case that there must be sufficient flexibility in developing areas of law, such as environmental law, for choices to be made in identifying, interpreting, and applying existing law to a particular legal problem or dispute. And in making those choices, lawyers, and in particular judges, and I quote, can be aware of the climate change, environmental harm, I add, consequence of each choice. So bringing all this together, there is scope for other non-regulatory challenge causes of action, but they will be highly fact sensitive and may need an adventurous approach by judges. Thank you very much.
Right. The slide said concluding remarks from me, but in fact, what I wanted to do is really just not make any concluding remarks, but engage in a bit of discussion and Q&A, really. So first of all, in relation to Stephanie's presentation, I suppose if we hadn't left the EU, then the next step in this saga might well have been the case coming back to the Court of Justice to consider imposing lump sum or ongoing daily penalties on the UK in the event of further non-compliance. And I know from my own experience that that's something that definitely concentrates the mind of the government. The prospect of being faced with a lump sum penalty is something that would very much worry the government. And of course, there is the possibility in law for the government to pass down lump sum penalties to local authorities if the non-compliance is due to them. And certainly having advised a number of local authorities in relation to clean air, they're all very worried about the political consequences of banning diesel cars, etc., but even more worried about the financial consequences of getting hit with a passed down lump sum penalty. So my question really is, where do we go from here with this case? Is it still possible? It would be highly controversial, obviously, but is it still possible that it could go back to the court to consider those sort of penalties against the UK?
Thanks, Stephen. Certainly under the withdrawal agreement, the Court of Justice of the European's jurisdiction continues beyond the transition period in respect of certain issues. So the key provisions in the withdrawal agreement are Articles 86(1) and Article 87. In terms of Article 86, if cases are pending before the Court of Justice at the end of the transition period, then they will continue until essentially they're finalised, which would include any ancillary proceedings, so decisions on appeals, that sort of thing. Article 87 essentially gives the European Commission 4 years from the end of the transition period to bring infringement proceedings against the UK for a breach of the EU obligations. In terms of the specific case, so any judgment that's been handed down by the Court of Justice within that 4-year period, falling in with those provisions, would remain binding on the UK. So it certainly would be open to further proceedings to be brought in order to seek some damages.
So possible, but certainly political dynamite, I would think. Yeah. Also, I suppose the other issue is that, we're not alone in Europe in being in breach of this directive. The failure is really widespread and probably equally systematic and persistent throughout many European member states, not just the UK. And that really sort of brings me on to a question, Catherine, the Trade and Cooperation Agreement and the non-backsliding provision, that's obviously predicated on it having some impact on trade or investment. And that seems to me to be, in the context of air quality, really quite difficult to see how poor air quality in a city necessarily would translate into something which is in breach of that provision of the TCA. I mean, I suppose if you had something like a new free port, the concept of free ports obviously is gaining some traction at the moment, being given an easy ride in terms of not complying with air quality standards versus its counterparts in Europe. That might be one thing, but I mean, just generally poor air quality seems to me to be quite difficult to really get any traction under that part of the TCA. I don't know whether you, Catherine, whether you want to comment on that or anybody else.
Stephen, I would agree, and I was trying to think of an example where you could, hypothetical, where you could show that a decision to not keep pace with EU targets going forward gave the UK an investment advantage. I can't see that. I suppose the only other thing is that there are these commitments which are softer and harder to enforce, but to strive to increase environmental protection, to abide by the precautionary principle. And there is, I think this is really important in this area, there is a clear political will, at least there currently is. So I think unless there's a sea change in the political attitude towards dealing with air quality as a problem, the reduction in hard-edged legal obligations, or the entrenched legal obligations, because there are hard-edged legal obligations, they're just a bit precarious in legal terms, then I don't see there being a huge divergence. But who knows what the future brings in terms of where this falls on the political agenda, and that's the real issue, I think. Oh, you're on mute, Stephen, sorry.
I'm asking somebody to unmute themselves, and I'm on mute myself. I mean, pots and kettles, etc. So there we are, Nigel.
I just wanted to pick up where you started, and that's the fact that over the next few years there will be other states who are brought before the European Court, and we may have the testing of the persuasive precedent effect of such decisions tested against the kind of non-intrusive approach that we've seen in recent cases in the UK. And I find that an interesting area, particularly, of course, in climate change, but why not also in air quality? Will our court start looking at decisions from the High Court in Lahore or from decisions in California when looking at the worldwide approach to environmental issues such as air quality and climate change? I think that's a really developing area, and I look forward to seeing if we do have adventurous judges, or whether post this challenge to a judicial review, the recent report, they will back away.
That's very helpful, Nigel. I was going to ask a follow-on for that and invite also Stephanie and Catherine to contribute to it. I mean, it does seem to me that a lot of this is critically dependent upon A, organisations bringing cases, and B, a reasonably receptive judiciary hearing them. And it's striking, isn't it, as I think was said in one case, that all of this has come about through a very modestly resourced NGO of limited size, Client Earth, being very persistent and finding, obviously, in Mr. Justice Garnham, a receptive judge. I mean, it does seem to me generally, with respect to them, that the senior judiciary are quite a conservative bunch. I mean, they're, with a small c, they're not really very happy getting into these sorts of arguments or into issues of fact. That's a real problem, I think, actually. Does anybody see any signs of that changing, or ways in which it might change? Nigel?
Well, it's not changing, it's the opposite. And I'm sorry to talk again about Heathrow. The Supreme Court decision on the climate change aspects of the challenge have been greeted with some disappointment outside the UK when talking about policy. Now, the courts are, of course, not interested in interfering with policy, but when they come to interpret what is meant by policy in the Climate Change Act, they could have taken a liberal, adventurous approach, or they could have taken an old-fashioned approach, without any disrespect to them. And so observers from outside the UK are disappointed by that part of the judgment.
Yeah, I don't know whether either Catherine or Steph has anything you'd like to add to that. Yes, Catherine.
I think two things. One is that it may be, this is why Nigel's presentation is so interesting, it may be important to look beyond the administrative court to try and make some progress here, and not just focus on central government, but bring pressure onto other private parties, and in the context of courses of action where you can actually obtain damages. So that's one thing. And then the second thing is also to just, my view of the way things are going is it's going to be about keeping this on the political agenda and keeping the political pressure up. So litigation that is strategic should be thinking about how it maintains that political interest in achieving these air quality targets that have been set, because that will probably be more persuasive than an order from the court to produce a better plan sooner.
Yes, Steph, please.
Thank you. Just building upon the first point that Catherine made, as I see it, I think there is a kind of two-pronged approach to the litigation. On the one hand, you focus on victims, so to speak. So the ones who can bring claims under Article 2 of the Human Rights Act, those who can look at potential Human Rights Act damages claims. And the other side, you look at the sources of the emissions. So for example, looking at the regulatory standards for car manufacturers, aviation, and then the cross-section between the two. So for example, some interesting cases coming forward, for example, in respect of the product liability claims against the car manufacturers, the misrepresentation claims. So I think it is just then kind of thinking creatively in that regard. But in terms of the point that you raised before in respect of small NGOs and small groups, I mean, certainly that is the case, but often you see them grouping together. So for example, the Good Law Project quite recently grouped together with Mums for Lungs and 2 youth climate change groups, and actually sent some pre-action correspondence in respect of the link between COVID-19 and air quality, which again raises some really interesting and innovative arguments around Article 2, Article 8, and the precautionary principle.
Yes, in fact, I was involved in that case for the government, and the permission was refused on the papers to the Good Law Project and the other claimants by Mr. Justice Robin Knowles, and it then went to quite a long, I think about half a day, renewed hearing in front of Mr. Justice Garnham, actually, who upheld the refusal of permission of Mr. Justice Knowles. I think it was, in some ways, it wasn't the best case to bring. I sort of feel it was being set up really as a big set piece case about whether the precautionary principle was a freestanding principle of domestic law, and the claimants had a massive appendix of running to about 300 different authorities of their grounds. All of these cases, public international law cases in other jurisdictions, all about precautionary principle. But at the end of the day, I mean, what they'd asked the Secretary of State to do was to consider revising the National Clean Air Strategy in the light of COVID, because they said there were more serious risks presented by COVID in a non-clean air environment, i.e. if you've got asthma or something which is exacerbated by bad air, you're more likely to get very ill from COVID. And also the possibility, although it's not proven, but there are hypotheses about it, of particulates acting as sort of vectors which aid the transmission of COVID. But I mean, in the event, what the Secretary of State said was, I'm not going to review the Clean Air Strategy, but I'm not ruling out this is a problem, and the expert groups are keeping it under review. So I think it was very difficult to argue the Secretary of State was denying precautionary approach. She certainly wasn't saying that I'm not looking at this because there's no proof. She was saying there may be something in it, but I'm keeping it under review. So, you know, very interesting case legally, but factually probably not a very strong case to have brought, really. But anyway, there we are. We did have one question that's come in, I noticed, which is, do we think that local authorities may backtrack on clean air zones? And if they do backtrack, get away with it? Well, I mean, I think it's very difficult to be generalistic about that, actually. I mean, I've acted for Transport for London and a number of other local authorities in relation to clean air zones, and their attitude seemed to me to vary quite widely, you know, and it's politically, I think it was quite straightforward actually for London to impose these measures. I mean, they were controversial, but they weren't political suicide for the mayor to impose. Whereas, you know, imposing a ban on vehicles from large swathes of a city could be really rather adverse when elections come round. And I think that is probably the worry of local authorities. You know, it's that the public may not share our perception of the need to do something about it if it involves curtailing their use of cars. So there may be some backtracking. I don't know, it could be political, whether they'll get away with it. I mean, my perception is that DEFRA has been behind the scenes, it's not very overt, but behind the scenes has been quite good at keeping on the back of local authorities who are recalcitrant and making sure they are coming forward with proposals. But, you know, who knows? That may change. We obviously have a very strange economic climate, don't we, following COVID, and the need to get the economy going again may assume greater prominence. So I think there may be some backtracking. I don't know whether they'll get away with it. It's possible. I don't know whether anyone else has any thoughts on that. Yes, Stephanie.
Just in terms of the Court of Justice's judgment, what is interesting is they do specifically refer to clean air zones as being the only appropriate measure that's properly modelled. And therefore it's quite interesting in that regard, because in terms of ensuring the exceedance period as short as possible, I imagine there might also be some pressure from that side of things to ensure that clean air zones are implemented in order to achieve the obligations under, well, obviously, the retained EU law.
Yeah, thanks. There's one other question that's come in, and I think that may have to be our last one possibly. It's actually kind of follows on a bit from the Good Law Project and the Mums for Lung project case, and that is in the context of the causation and the precautionary principle, and if one is looking at claims where the evidence may be, you know, not very individual specific, it's relying on population-wide studies. It may be very difficult for an individual, unlike some of those cases about inquests, to prove definitively that air quality is having a serious effect on them. Do people feel that looking forward, the role of the precautionary principle might help in overcoming those difficulties? So if someone were, for instance, to bring, in Nigel's scenario, a nuisance claim or an Article 2 human rights claim, and it said, well, there's no evidence, this is doing you any harm, how might that play out in terms of evidence, causation, and the precautionary principle, do people think? Nigel?
If I can respond briefly, it's a very good question, but it's whether there's any role at all for the precautionary principle in a damages claim case. There may be examples out there. I haven't seen any that I can think of. The problem with the precautionary principle is it's dealing in terms of action that needs to be taken before the science is absolutely clear. The latest, perhaps, example is taking a vaccination off the market when there's some concern about blood clots. But if you take the vaccination and you suffer a damage from it, health harm, you wouldn't be relying on the precautionary principle, you'd be relying on expert evidence that this was a known risk, that you were encouraged to take the vaccination and you suffered harm. Now, translating that to air quality and the coroner's recent decision, although we haven't seen his full reasons, which takes me then back to the Alex Samuels article, it is possible to produce expert evidence, Professor Holgate in that case, to show that a particular state of affairs contributed to the health of a particularly vulnerable individual. But otherwise, you'll be going back to the type of cases, Stephen, that you and I did about cement works in Coventry, that working out and back to the old negligence and nuisance cases about smuts on washing. You have to make the causative connection either by obvious fact or by expert evidence. And another day, perhaps we can all talk about expert evidence in public law cases, but in civil cases, at least there will be an opportunity to prove that the causative link exists.
Thank you, Nigel. There was one further question, which is, does Natural England have any role to play in this? Well, of course, we've been focusing on the public health implications of air quality, but we mustn't forget that air quality does have serious implications on the environment. Certain plants obviously are very susceptible to certain air pollutants, and indeed we have seen how, for instance, in areas like the Ashdown Forest, the fallout from vehicles of nitrogen does present a quite serious constraint to new housing projects. So Natural England, as advisors to the government and to local government, yes, definitely have a role to play there in advising on whether critical thresholds for damage to plants are being exceeded or would be exceeded by a growth in traffic caused, for instance, by new development. So I think we'll have to probably wrap it up there. Just to say again, thank you for attending, and you will get the details, our slides, and also Nigel, in many cases Nigel referred to the references for those, so you'll be able to dig into those cases that he mentioned. So I hope that's been enjoyable and informative, and given some further food for thought, and we look forward to seeing you at future events in due course. So I will say goodbye now, and I hope you enjoy the rest of the day. Goodbye.
Bye.